Before anyone jumps to conclusions, we need to slow this down, not because nothing happened, but because what happened matters far more than how it's being framed online. A 32-minute audio recording is now circulating in connection with the Patrick Roark exploitation case. The call is between Patrick and a longtime acquaintance who was allegedly expected to arrive with a trailer and act as a form of informal security near the Whittaker property. This recording is not a rumor. It is not a reenactment. It is not commentary. It is a direct conversation, and that alone changes the evidentiary landscape. But here's the discipline point that has to be established immediately. A leaked call does not automatically prove a crime. It does, however, raise specific factual questions that investigators would be obligated to examine. This case has already crossed the threshold from online controversy into formal criminal procedure. Patrick Roark has been arrested, charged, and released pending trial. The allegations involve financial exploitation of incapacitated individuals, fraud schemes, and misuse of access devices. That means context is everything. So instead of asking, "Is this audio damning?" the correct question is, what does this audio, if authentic, suggest investigators would need to verify next? That's where this analysis begins. What the call is, and what it is not. The recording captures Patrick and the other individual attempting to reconstruct a confusing timeline around early September, specifically September 2nd and September 3rd. They are not calmly narrating events after the fact. They are actively trying to understand what happened in real time. That distinction matters. Throughout the call, several recurring themes emerge. Confusion about Patrick's physical location. Confusion about who was in possession of Patrick's phone. Confusion about who answered calls placed to Patrick's number. Confusion about why call logs reflected unfamiliar routing language. Confusion about conflicting Facebook posts versus private communications. This is not a polished story. It is a fragmented reconstruction, and fragmented reconstructions are exactly what investigators look for. Not because they prove guilt, but because they reveal pressure points where records can confirm or contradict memory. The core issue introduced by the call. There is one issue raised in this recording that immediately elevates it beyond internet drama: control of communication. Specifically, who had access to Patrick Roark's phone during critical windows of time? Why did calls to Patrick's number allegedly route through unfamiliar data identifiers? Why did a third party allegedly answer Patrick's phone while denying their identity? Why did social media activity contradict what callers were being told privately? These are not moral questions. They are technical and procedural questions. And technical questions leave trails. Why phone control is a big deal in this case. This case is not only about money. It is about access. Financial exploitation cases involving vulnerable adults almost always hinge on three things: control of accounts, control of narratives, control of communication. If investigators can establish that communication was intercepted, redirected, or managed by someone other than the account holder, especially during periods where decisions about the Whittakers' movement, access, or representation were being made, that becomes legally significant, not emotionally significant. Legally significant. The call does not prove interception occurred, but it introduces a claim serious enough that law enforcement would be expected to subpoena call logs, examine forwarding settings, review device access, compare timestamps against social media posts, identify who physically possessed the device during the relevant windows. This is no longer speculation territory. This is verification territory. Why the timing matters. The conversation repeatedly circles back to early September. That matters because September is already documented as a critical period in the Whittaker case timeline, a period involving escalating involvement by outside parties, changes in access to family members, increased content production, and the lead-up to later financial allegations. When multiple sources independently flag the same dates as when things stop making sense, investigators pay attention, not because it confirms wrongdoing, but because convergence is how timelines get locked. What this call does not do, let's be clear about boundaries. This recording does not establish guilt, confirm hacking, prove interception, validate claims about law enforcement conspiracies, demonstrate intent to exploit. Anyone saying it does is overreaching, but what it does do is undermine one very specific defense posture, that everything unfolded transparently and voluntarily. Confusion, contradictions, and unexplained access issues are the opposite of transparency. Why this matters for the Whittaker case specifically. This case involves adults described by authorities as vulnerable and in some instances incapacitated. In cases like that, courts and investigators look beyond surface consent. They examine who controlled information, who mediated decisions, who spoke for whom, and who shaped perception while others lacked capacity. If communication channels were compromised, even temporarily, that matters, because exploitation doesn't require force. It requires imbalance. Where this goes next, this leaked call does not end the story. It starts a verification process. The next steps are not public outrage or viral certainty. They are document-driven. Phone carrier records, device access logs, app metadata, social media timestamps, location data, witness corroboration. Those are the things that decide whether this audio becomes background noise or a supporting thread in an already active investigation. And that brings us to the question that sets up part 2. If this call is authentic, who benefits from confusion? And who is harmed by it? Comment one word below. Confusion or control. When investigators hear confusion in a recorded call, they don't dismiss it as chaos. They map it, because in exploitation cases, especially those involving vulnerable adults, confusion is rarely neutral. It's often functional, not accidental, not random, functional. And that's why this leaked call matters even before a single technical claim is proven. Let's be precise about what kind of confusion is present here. This is not confusion about feelings or motives. This is confusion about access, control, and timing. Those are the 3 pillars investigators look at when determining whether influence crossed into exploitation. The type of confusion that raises red flags. In the call, the speakers repeatedly return to the same unresolved questions. Why did calls to Patrick's phone route strangely? Why did a third party answer Patrick's phone while denying their identity? Why did Facebook posts contradict private communications? Why did access to Patrick suddenly change during a critical period? Why did attempts to physically assist or arrive coincide with blocking and narrative shifts? These aren't abstract concerns. They're operational. In cases involving vulnerable families, control of communication often becomes the quiet mechanism that determines everything else. Who shows up, who speaks, who decides, who is believed. Investigators are trained to recognize this pattern because it shows up again and again in exploitation cases. Confusion appears. Access narrows. Narratives consolidate. Outsiders are pushed out. Decision-making becomes centralized. Money flow follows the same path, not because someone planned it that way from the start, but because confusion creates leverage. Why confusion is power. Confusion gives one party something invaluable, plausible deniability. When no one can clearly explain what happened, the person with the most access controls the explanation. That's not a moral judgment. It's a structural reality. In the call, you hear two people trying to reconstruct events days later, cross-referencing timestamps, recalling posts, questioning call logs. That alone tells investigators something critical. The events weren't clear as they were happening. And when events aren't clear in real time, vulnerable people lose agency first, because they rely on others to interpret reality for them. Communication control as a gatekeeping tool. In exploitation investigations, communication control is treated as a gatekeeping function. Who answers the phone? Who blocks messages? Who decides which calls get through? Who speaks on someone's behalf? These decisions shape outcomes before money ever moves. If Patrick's phone was answered by someone else, even once, during a period when access decisions were being made, that matters. Not because it proves interception, but because it establishes possibility. Possibility is enough to trigger verification. And verification is how cases move forward quietly while the public argues loudly. Why investigators care about September. The call's repeated focus on September 2nd and 3rd isn't incidental. In many exploitation cases, there's a pivot window, a short period where dynamics change rapidly. New rules appear. Old relationships fracture. Access shifts. Stories stop lining up. Investigators look for that pivot. When multiple independent sources point to the same narrow time frame as when things stopped making sense, it becomes a focal point. Not because everyone agrees on what happened, but because everyone agrees something changed. That's exactly what this call reflects. The role of narrative in control. One of the most revealing aspects of the call is not technical, it's narrative. The speakers describe being told different things at different times. He's home. He's at an Airbnb. He's injured. He's unavailable. He'll call tomorrow. Meanwhile, social media shows activity that contradicts those explanations. That creates a split reality. In exploitation cases, split reality is dangerous because it forces people to choose which version to believe, and belief becomes loyalty. Once loyalty is tested, people who ask questions get excluded. That's not paranoia. That's pattern recognition. Why blocking is not a minor detail. At one point, the caller describes being blocked after publicly asking a restrained question. Investigators pay close attention to blocking patterns because blocking is not just social behavior. It's boundary enforcement. Who gets blocked tells you who is no longer allowed to witness. And when witnesses disappear, narratives harden. Again, this doesn't prove intent, but it defines structure. What investigators would do next. If this call were submitted to authorities, as the speakers discuss, it would not be treated as evidence of guilt. It would be treated as a lead. Specifically, it would prompt questions like, do carrier records show call forwarding during the relevant window? Were multiple devices logged into the same accounts? Do device IDs match posting activity? Who had physical possession of the phone? Were there periods of location mismatch? Do other witnesses report similar access confusion? These questions are quiet. They don't trend. They don't leak, but they matter. Why this is about structure, not character. One of the biggest mistakes the public makes is turning structural analysis into character judgment. This isn't about whether someone is good or bad. It's about whether systems of access became unbalanced in a way that allowed exploitation to occur. People with good intentions can still create harmful structures. People with no malicious plan can still benefit from confusion. That's why investigators don't argue motives. They document mechanisms. The danger of public overinterpretation. Here's the risk, right now. If the public decides this call proves everything, pressure builds in the wrong direction. If the public decides it means nothing, pressure disappears where scrutiny may be needed. Both extremes distort the process. The responsible position is the uncomfortable one. This call raises legitimate questions that deserve verification. Nothing more, nothing less. Why the Whittakers remain the center. Amid all this analysis, it's easy to forget the most important fact. This case exists because a vulnerable family was allegedly exploited. Every technical question, phones, access, calls, timelines, matters only because of who it affected. Confusion didn't just inconvenience adults arguing logistics. It may have shaped who spoke for people who could not speak for themselves. That's why investigators take confusion seriously, not because it's dramatic, but because it creates conditions where harm can hide. Where this leaves U.S., this leaked call does not end the case. It doesn't even define it, but it sharpens the lens. It tells investigators where to look. It tells analysts what to verify. It tells the public to slow down. And it leads directly to the next question, one that decides whether this confusion was incidental or instrumental. In Part 3, we examine what happens when confusion is paired with money movement, and why that combination is where exploitation cases are actually proven or disproven. Comment below. One word: incidental or instrumental. Your answer says a lot about how you think this case should be evaluated. Confusion alone doesn't make a criminal case. Money alone doesn't either. But when confusion and money move together, especially around vulnerable people, that's where exploitation cases stop being theoretical and start becoming prosecutable. This is the point where investigators stop asking what went wrong and start asking who benefited. And that's why Part 3 matters more than any leaked call, clip, or argument online. Because courts don't decide exploitation based on vibes. They decide it based on control, benefit, and impact. The core question investigators always ask. Strip everything else away, and every exploitation case narrows to one central question: who controlled the situation and who benefited from that control. Not who talked the most, not who appeared on camera, not who sounded convincing, who had the ability to decide what happened to resources, especially money, when the people affected could not fully advocate for themselves. Everything else is supporting evidence. Why money doesn't have to be stolen to be exploitative. This is where public understanding often breaks down. People assume exploitation requires outright theft. It doesn't. In many jurisdictions, exploitation includes misuse of funds, redirection of benefits, failure to distribute promised proceeds, using a vulnerable person's presence, labor, or likeness for gain, exercising financial control without informed consent. Intent matters, but impact matters more. If money moves because confusion existed, and confusion existed because access was controlled, investigators start connecting dots. the sequence that raises legal flags. Investigators don't look at money in isolation. They look at sequence. And the sequence suggested by the call matters. Access disruption. Phones unanswered. Calls redirected. Messages blocked. Narrative instability. Different explanations given at different times about location, condition, availability. Third-party intervention. Someone else speaking, answering, deciding, filtering. Public-facing activity. Social media content continues, often monetized or engagement-driven. Private exclusion. Individuals who ask questions lose access or are shut out. Money remains centralized. Funds don't flow outward transparently, while visibility stays high. That sequence doesn't prove exploitation, but it's the exact pattern investigators are trained to scrutinize. Why? Social media changes, financial liability. This case exists in a modern reality. Money doesn't only come from envelopes or bank withdrawals anymore. It comes from monetized videos, donations, platform engagement, algorithmic amplification, indirect benefits like housing, travel, services, and influence. When vulnerable individuals appear in content that generates money, investigators ask, who controlled the account? Who received payouts? Who decided expenses? Who understood the agreements? Who paid taxes? Who carried risk? Confusion around phones and access suddenly becomes relevant because it overlaps with account control. And account control is financial control. Why everyone benefited is not a defense. A common argument in cases like this is, but everyone got something out of it. That doesn't end an exploitation inquiry. Courts look at proportionality and agency. Did the vulnerable individuals understand how money was made, how much was made, how it was divided, what alternatives existed, what rights they had to say no? If someone else answered phones, filtered access, controlled schedules, and spoke on their behalf, informed consent becomes harder to establish, and the burden doesn't fall on the vulnerable party to prove confusion. It falls on the controller to prove clarity, the legal difference between helping and controlling. Many exploitation cases involve people who believe they were helping, and many of them were, at least at first. But there's a legal threshold where help becomes control. Helping assists without replacing agency, increases options, is transparent, can be withdrawn without retaliation. Control replaces decision-making, narrows options, depends on confusion, punishes questioning. Blocking someone who asks about logistics may seem minor socially. Legally, it can indicate boundary enforcement, especially when money is involved. Why timing matters more than totals. Another misconception is that investigators focus on large sums. They don't, at least not first. They focus on timing. If money moves after access narrows, that matters. If payouts stall after narratives change, that matters. If benefits continue privately while transparency decreases publicly, that matters. Small amounts repeated under opaque conditions can matter more than one large payment made openly. What financial records would clarify? If authorities are pursuing this case seriously, and indications suggest they are, they will already be looking at platform payout records, donation histories, linked accounts, IP logins, device access, expense patterns, timing of posts versus communications, who paid for what and when. This is not dramatic work. It's slow, quiet, methodical, and it doesn't care about online arguments. Why confusion can become a shield. One of the most dangerous dynamics in exploitation cases is intentional or unintentional obfuscation. When everything is confusing, responsibility blurs. People can say, "I thought someone else handled that. I didn't know. It was unclear. They never asked." But courts don't accept confusion as a permanent excuse, especially when one party had consistent access and others didn't. Confusion is tolerated briefly, then it becomes a liability. The Whittakers, as the measuring stick, everything circles back to one standard. Did this arrangement improve the Whittakers' autonomy, stability, and understanding, or did it diminish it? That's the question that matters legally and ethically. Not who sounded convincing, not who posted first, not who got attacked online, but who ended up with more control and who ended up with less. Why this part is hard for the public. Money analysis is boring. There are no clips, no sound bites, no heroes or villains, but it's where truth lives, which is why so many people would rather argue about calls, phones, and personalities. Those are loud. Money is quiet, and quiet is where cases are won, where this leaves the story. At this stage, nothing in the leaked call proves exploitation, but it explains how exploitation could happen. It explains the conditions. It explains the vulnerabilities. And it explains why investigators don't need a confession or a viral moment. They need records. Which brings us to the final structural pillar. In Part 4, we examine agency and consent, what it actually means legally when vulnerable adults are involved, and why saying they agreed is often the weakest defense of all. Because agreement without understanding isn't consent, and consent without agency doesn't hold up in court. If you're following this responsibly, stay there. This is where the case either collapses or solidifies. This is the part most people misunderstand, not because it's complicated, but because it sounds simple when it isn't. People say things like, "They agreed," "They didn't complain," "They were fine with it," "They went along with it." And in everyday life, those phrases might be enough. In exploitation cases involving vulnerable adults, they are not. Because the law doesn't treat consent as a single word. It treats it as a process. And that process depends on agency. What agency actually means in legal terms. Agency is not independence. Agency is not intelligence. Agency is not whether someone can speak, smile, or show up on camera. Agency is the ability to understand what is happening, understand alternatives, understand consequences, make choices without pressure, withdraw consent without penalty. If any of those elements are missing, consent becomes unstable, not invalid automatically, but questionable. And when money, control, or access is involved, that question gets very sharp, very fast. Why vulnerability changes the standard. In ordinary adult interactions, the law assumes capacity unless proven otherwise. In cases involving adults with intellectual disabilities, cognitive limitations, or dependency structures, the standard shifts, not to "they can't consent," but to "did the person seeking benefit ensure understanding?" That's a crucial difference. The burden doesn't fall on the vulnerable person to object. It falls on the person in control to demonstrate clarity. Why? They never said no doesn't work. Silence is not consent, especially when access is filtered. Phones are controlled. Transportation is dependent. Housing is unstable. Care or safety feels conditional. In those environments, silence is often survival. Courts understand this. Investigators understand this. That's why they don't ask, "Did they object?" They ask, could they safely object? The role of dependency. Dependency doesn't have to be total to matter. Partial dependency is enough. If someone relies on another person for transportation, communication, interpretation, access to outside help, financial management, safety or supervision, then consent must be examined in context. Because saying yes when saying no could cost you stability is not free choice. It's negotiation under pressure. Why agreements are not the same as understanding. This is where verbal agreements collapse under scrutiny. A person can repeat words without understanding implications. A person can agree to something without understanding how long it lasts, how much money is involved, who controls the funds, what happens if they change their mind, what rights they're giving up. Investigators don't just ask what was agreed to. They ask, how was it explained? Who explained it? Were alternatives offered? Was independent advice available? Was the explanation repeated over time? Was consent revisited? One-time agreement is weak. Ongoing informed consent is strong. Why third-party control undermines consent? When someone else answers calls, speaks on behalf of another, filters questions, manages schedules, controls devices, decides who gets access. Consent becomes mediated, and mediated consent is fragile because the person agreeing is no longer interacting directly with reality. They're interacting through a gatekeeper. That doesn't automatically mean wrongdoing, but it raises the bar for proof of ethical conduct. The problem with they liked it. Enjoyment is not consent. This sounds counterintuitive, but it's legally precise. A person can enjoy attention, outings, structure, gifts, routine, and still be exploited, because exploitation isn't about suffering. It's about imbalance. Someone can smile while being controlled. Someone can participate while being misled. Someone can appear happy while losing agency. That's why investigators don't ask, did they seem happy? They ask, did they have power? Why power matters more than intent. Many people involved in exploitation cases insist they meant well, and some of them are telling the truth. Intent matters morally. Impact matters legally. If one party had power and the other didn't, the law doesn't allow intent to erase responsibility, especially when the empowered party benefited financially. The legal red flags around consent. In cases like this, investigators look for specific warning signs. Consent given once and never revisited. Consent explained by the benefiting party. Consent without independent witnesses. Consent without documentation. Consent that coincides with increased control. Consent followed by isolation. Consent that can't be withdrawn without consequence. None of these alone prove exploitation. Together, they form a pattern. And patterns are what courts decide cases on. Why they could have left is often false. Another common defense is, they could have walked away anytime. That assumes they knew they could. They knew how. They had somewhere to go. They had access to help. They wouldn't be punished for trying. If someone doesn't know their options, options don't exist. And if leaving means losing safety, stability, or connection, staying isn't free choice. It's constrained choice. What true consent would have looked like. This isn't hypothetical. There is a way to structure involvement ethically. True consent would include clear explanation in plain language, repeated check-ins, independent advocates, transparent accounting, separate access to phones and contacts, freedom to say no without consequence, ability to stop participation without retaliation. If those elements are missing, consent becomes vulnerable to challenge. Why courts care about process, not promises. People often say, "But I promised to pay. But I plan to help. But it was temporary." Promises are not safeguards. Processes. Courts ask, what systems were in place to prevent harm? If the answer is trust me, that's not a system. That's a risk. How this connects back to the leaked call. The leaked call doesn't prove exploitation, but it raises questions about who had access, who controlled communication, who spoke for whom, who decided logistics, who filtered information. Those questions matter because they intersect with consent. When access narrows, agency narrows. And when agency narrows, consent weakens. Why this is often misread as attack. Pointing out agency issues isn't accusing someone of evil. It's acknowledging responsibility. Exploitation cases aren't about villains. They're about systems that allowed imbalance to grow unchecked. And once imbalance exists, harm doesn't require cruelty. It only requires continuation. What the court will ultimately ask. When this reaches its critical phase, the question won't be, did people argue online? It will be, did the Whittakers have meaningful agency in decisions that affected their money, image, access, and lives? Everything else is noise. Where this leaves us. By the end of Part 4, one truth should be clear. Consent is not a shield if agency was compromised, and agency is not assumed when vulnerability exists. Which brings us to the final piece. In Part 5, we look at accountability and outcomes. What happens when courts decide exploitation didn't require malice, only imbalance, and what that means for everyone involved moving forward. Because regardless of intent, consequences don't disappear. They just arrive quietly on paper when the record is complete. And that's where this story is headed. By the time a case like this reaches its final phase, the loud questions have already burned out. What's left are quiet ones. Not who said what online, but who held power, who benefited, and what safeguards failed. That's where accountability lives. Accountability is not moral judgment. Courts are not interested in deciding whether someone is a good or bad person. They are interested in determining whether harm occurred, whether it was preventable, whether responsibility followed power, whether benefit followed control. You don't need cruelty for exploitation to exist. You don't need intent for accountability to attach. You only need imbalance that produced gain. Why everyone lost doesn't end the case. People often argue that no one won, so no one should be blamed. That logic doesn't hold. If one party gained access, money, influence, or control during a period where another party lost agency, stability, or autonomy, the law doesn't call that mutual loss. It calls it allocation of responsibility. Loss doesn't cancel liability. It clarifies it, what the system actually measures at the end. When investigators and prosecutors close in on resolution, they focus on documents, not narratives. They ask, who controlled accounts? Who decided access? Who filtered communication? Who set terms? Who could stop the arrangement? Who couldn't? And most importantly, who benefited materially or strategically? That's not emotional. That's arithmetic. Why lessons learned is not a legal outcome. Some people hope these cases end with understanding instead of consequences. Understanding may exist privately. The law still acts publicly. Because without consequence, the same patterns repeat. often with different families, different names, and the same vulnerabilities. Accountability isn't punishment for its own sake. It's boundary setting. What closure really looks like. Closure doesn't arrive with apologies or explanations. It arrives with clear findings, defined responsibility, protective orders where needed, restitution if warranted, restrictions on future access, formal recognition of harm. It's procedural, and because it's procedural, it doesn't feel dramatic. It feels final. Why the Whittakers matter beyond this case. This case isn't just about one family. It's about how systems respond when vulnerable people become visible. Visibility attracts help, but also opportunism. And when oversight fails, visibility becomes exposure. What happens here will quietly shape how future cases are handled, how consent is evaluated, how access is regulated, how third parties are monitored, how protection is defined. That's the real legacy. What the public's role is and isn't. The public doesn't decide guilt. The public doesn't enforce accountability. But the public can avoid making harm worse. That means no speculation presented as fact, no harassment framed as justice, no turning vulnerable people into content, no rewarding imbalance with attention. Watching responsibly is not passivity. It's restraint. The final truth. Exploitation cases don't end with a villain exposed or a hero crowned. They end with paperwork. And those pages don't ask who meant well. They ask who had power and what they did with it. That's the standard. That's the line. And once it's crossed, intent stops mattering. Only responsibility remains. Thank you for watching this video. Click here to watch another video that might interest you.